The legislature mandates that the only appropriate sentence for the jury's verdict, murder in the first degree, is life in prison without the possibility of parole.
And we're getting the judges.
That sentence is immensely appropriate and just, given your murderous acts and the life trauma that you've inflicted upon your own children.
Get him, Your Honor. It's Thursday. It's December 18th. We are here for the sentencing of Brian Walshe. Yes, the jury just came back on Monday with a guilty verdict. Yes, sentencing is today. Why? Well, there's not a ton that needs to be done before sentencing in this case, and it was scheduled for yesterday and then put over for a day. I think it was put over for a day because, as we have heard the judge say numerous times, she wanted to make sure she had the impact statement that the children were working on with their social worker. Those are going to be impounded. They're going to be sealed. We're not going to see them. We're not going to hear them read onto the record. But the court wanted to make sure that she had them. And the court said that if she did not have the letters from the children through the social worker for the file, she was going to put over sentencing until she had them. I expect, given that it was just a one-day delay, that a little more time was needed to file those with the court, get them to defense, and get them sealed. So what are we looking at sentencing today? We know that Brian Walshe is going to be sentenced to life without parole. That's not discretionary. The court does not have a choice. If convicted of first-degree murder, then sentenced to life, period, LWOP, life without parole, goodbye, that's it. No options, non-discretionary. The court does not have a range. But we have heard the defense bring up the issue a couple times, and the court said she was going to put over the issue until after trial of what the sentence is on the essential obstruction of justice count, because it is a 10-year sentence if it is obstruction on most crimes, but it can be a 20-year enhancement. And I'm curious to see if in Massachusetts enhancement means plus or enhancement means this is a elevated or enhanced sentence. It's more time. So that would be 20. If it's an enhancement, like California uses the word enhancement, then it's a plus. I suspect it's a 20, not a 10 plus 20, making it 30. But we'll see. Is it going to matter at the end of the day? Well, there's appeals. It could matter for the purpose of appeal, but at the end of the day, he's got the federal sentencing that he needs to finish, a LWOP sentence, 10 or 20 years. But the defense was arguing that the 20-year enhanced sentence doesn't apply. Why were they arguing that? Well, they were seeming to argue that he was obstructing or lying with relation to the improper disposal. That count carries 3 years, and that's count 3. So the defense is arguing that count does not carry a life sentence. He was lying to police in connection with that. So because it doesn't carry a life sentence, he gets the lower one. The only reason that Ana Walshe's body was gone is because in the early morning hours of January 1st, 2023, Brian Walshe murdered her and didn't want to get caught and didn't want her body to be in the house. That's a life crime. You get the higher one. Or at least that's how I see it. We'll see what the judge decides to do with that. I am curious to see if the judge sentences these concurrently or consecutively. I think they'll be consecutive after the other. I want to see the judge say that this starts after the federal case. Federal sentencing, consecutive. Then you can finish your federal sentencing. Then you can start your life, the rest of your life, all life. Today is also the opportunity for victim impact. We will hear the attorneys argue for a sentence. The defense can really only argue the discretionary sentences on counts 2 and 3. I think he's just going to get all of it. And then we will see if the judge has anything to say to the defendant. And we will see if the defendant has anything to say to the judge.
My name is Alexandra Dmitrievich. And
I really appreciate that the judge got up from the other side of the bench. This is a large bench for the judge. Got up from the other side of the bench and came to stand by the victim's sister and listen to her statements.
I'm the sister of Ana Walshe. I am here today to represent myself and my mother. I want to share with the court how losing my sister in January 2023 has forever changed our lives and left us with an unbearable emptiness.
Yeah.
Losing my sister Ana so unexpectedly has altered our world in ways we never imagined. Ana was not just my sister. She was someone I grew up with, someone who knew me in ways no one else ever will. I struggle with the grief that comes without warning, hoping every morning that this is all just a terrible dream. The most painful part of this loss is knowing her children must now grow up without their mother's hand to hold. They now face a lifetime of milestones, big and small,
She is looking
where
right
her
at the defendant.
absence will be deeply and painfully felt. This tragedy has also devastated my mother. She has developed severe depression and chronic exhaustion. Every single day, she carries the weight of losing her daughter.
Yeah.
Our entire family is still learning how to live with this emptiness. Holidays and birthdays are now silent reminders of her absence. Because of the circumstances of my sister's death, we were denied the opportunity to say a final goodbye and to observe our customs, adding a layer of profound, unfinished grief to our loss. Ana was a mother, a daughter, a sister, and a friend. Her life was unfairly taken. We miss her beyond words. While we recognize that no sentence can bring her back, we ask the court to consider the permanent, long-lasting impact this loss has had on our family, especially her children. We stand in agreement with the Commonwealth and their recommendations. Finally, I would like to extend our deepest gratitude to the investigators, the Commonwealth's office, and everyone who has worked tirelessly on this case.
Great job.
Your dedication to seeking justice for my sister has provided our family with a sense of support during our darkest hours.
You're doing a great job,
Your
ma'am.
Honor, thank you for allowing me the opportunity to share the full weight of this incomprehensible act.
It's hard to put words to
Ana
that
will
kind of
never
pain.
be forgotten. We will carry her light and her memory with us forever. Thank you, Your Honor.
The Commonwealth is requesting that the defendant be sentenced to a series of consecutive sentences on the charges to run from and after his federal case, in which he received a sentence of 37 months in February of 2024. The first charge that the Commonwealth would seek an incarceration component on is count 003, and that the defendant be sentenced to 2.5 to 3 years. The second charge would be that he, on the misleading 002, to run from and after 003, that he receive a sentence of 18 to 20 years. And that the third charge, the murder, and the first degree, that the defendant be sentenced to life without the possibility of parole to run from and after 003 and 002. And Your Honor, if I may be heard in our argument.
Please.
Thank you, Your Honor. When you look at the facts of these three charges, each one calls for a harsh penalty. If you look at the illegal conveyance of a body, the defendant did not just, the person that he illegally conveyed was his wife and the mother of his 3 children. And he did it by removing her remains from the family home and placing them in buckets, in garbage bags, in dumpsters around the Commonwealth. He denied, as you just heard, her family the opportunity to have any customs or burial. There is no grave, there is no memorial. And he did this all in an effort to destroy evidence. On the misleading component, Your Honor, while we do mention the potential of probation, we put that in there only as data so that you understand the efforts that went in to trying to find Ana based on the defendant's series of lies. These lies were all done in an effort to cover up his crime and destroy evidence. We're also, while we put in that, we are not seeking a probation sentence, but we put it in there so the court, if it wanted to contemplate one, understood there was an option to do it. that would prevent the defendant potentially from trying to profit from this. To reach the level of cruel and unusual punishment, the punishment must be so disproportionate to the crime that it shocks the conscience and offends the notion of human dignity. I don't know if that's possible in this case, Your Honor, because human dignity was completely offended by the defendant's actions and how he treated his wife, how he disposed of her, and how he robbed her family and friends of the opportunity to bury her. There is no death certificate. The church will not allow a funeral to go on at this point in time. We are working on trying to work with the ME's office to see if we can get a death certificate to issue now based on the conviction and based on the plea. And when I looked behind me after the closing arguments, I realized that was the closest thing that those people had come to a wake, because they never got together to mourn her. And that happened 3 years later. So with that, Your Honor, the Commonwealth does make a punishment that we recommend to you. We recognize it's harsh, but we think it's appropriate based on the facts. And I appreciate your time, Your Honor. Thank you.
With respect to the first-degree murder conviction, although we made it clear from our memorandum that we do object to a life without parole sentence based on state and U.S. constitutional grounds, based on the Eighth Amendment, we understand the court has no discretion. With respect to indictments 2 and 3, you do. I think inhumane is the right word, respectfully. To sentence someone to prison posthumously to send a message is humane. It's dehumanizing him. Regardless of what happened in this courtroom, regardless of the convictions, regardless of what anyone believes about this person, he is a human. He is a father, he is a son, and he has been a friend to many. The life sentence is mandatory, but to do consecutive sentences, I think, is inappropriate and is inhumane. Anytime there is a death, a murder, a loss of life, it is horrible, whether it's a loved one or a stranger. And the legislature has provided, regardless of our disagreement, that a life sentence without parole is mandatory. But that does not negate that he is a human being. And I don't think sentencing him to on and after time is appropriate. Just because you can doesn't mean you should. What he was convicted of were atrocious acts. We've heard from her family, we've heard from her friends. Their pain is unimaginable, and I'm not demeaning that, but I have the opportunity to speak for Brian today. And I'm asking the court to sentence him in line with the guidelines and with the purpose of sentencing: punishment, justice, prevention of future crimes, consecutive sentences. That's excessive, and it doesn't meet those needs. So I'd ask the court to adopt the defendant's sentencing recommendation.
There is no task facing a judge that is more important or more difficult than crafting an appropriate sentence. The legislature mandates that the only appropriate sentence for the jury's verdict, murder in the first degree, is life in prison without the possibility of parole. That sentence is immensely appropriate and just, given your murderous acts and the life trauma that you've inflicted upon your own children. As to counts 2 and 3, I have wide discretion in sentencing. I want to state my rationale for your sentences on those 2 counts on the record now. I have considered various factors with regard to my sentence for counts 2 and counts 3, to which you pled guilty on November 18th, 2025. Specifically, I've considered the severity of the crimes, their nature and circumstances, and your role in those crimes, the need to deter others from committing comparable crimes, and your prior criminal record, namely your federal fraud case. As to the latter, your criminal history shows a long and well-documented history of deceitful and manipulative behavior. I've considered your character, or lack thereof, your behavior, and your background. With regard to the nature and circumstances of the offenses, as to indictment 002, In the approximately 4 hours of interviews spanning 4 days, you concocted a detailed, completely fabricated story of what happened to Ana Walshe on January 1st, 2023, in order to cover up your murder of her and disposal of her body. Your lies triggered a multi-day, extensive missing persons investigation. A command center was set up in Cohasset and was manned by various law enforcement, to include the Cohasset Police Department and the Massachusetts State Police. And local and Massachusetts resources were deployed to Washington, D.C. to investigate at Ana's home. Because of your lies, thousands of hours of investigative resources were wasted and diverted from other deserving cases and investigations. As to the nature and circumstances of count 3, the improper disposal of Ana Walshe's body, the seriousness of your acts cannot be overstated. Your acts in dismembering your wife's body and disposing of her remains in multiple area dumpsters can only be described as barbaric and incomprehensible. You had no regard for the lifelong mental harm that your criminal acts inflicted on your then 2, 4, and 6-year-old sons, not only in taking their mother, but also, as is specific to this charge, in never being able to properly grieve that loss, to say goodbye to their mom. And I hear today the same is equally true of a sister who never was able to say a proper goodbye to her sister, a mother who never was able to say a proper goodbye to her daughter, and many friends who had the same loss. As to indictments 2 and 3, I have considered the sentencing guidelines, the aggravating factors. There are no mitigating factors in this case. And I also sought out and considered information from the Massachusetts Sentencing Commission, again, which I shared with the parties earlier this week, in particular sentencings in 2022 and 2023 of defendants who were convicted of murder and or voluntary manslaughter, along with a Chapter 268, Section 13B conviction. This is not a guideline case. Finally, as to the first-degree murder conviction, I have considered the loss of the life of an innocent, remarkable woman, Ana Walshe, and its devastating impact on her children, as relayed to me in the letter from DCF, her family, as relayed to me in her sister's victim impact statement today, friends in their victim impact statements, in the community. In the trial testimony of Jem Mutlu and Alyssa Kirby, a little bit of Ana Walshe, her warm, powerful, and embracing spirit came to life in this historic courtroom. I have carefully listened to the moving victim impact statement, to the oral written sentencing arguments made by the Commonwealth and by Mr. Walshe. It's clear to me that Ana was a bright light in the lives of many people. She lifted people up. I am sure that nothing I say and no sentence I can impose, even a life sentence, will lessen the grief that Ana Walshe's family, her mother, sister, and 3 boys, extended like family, confidants, friends, and others have endured and will continue to endure. Although I consider the letter of Diane Walshe, I simply cannot reconcile the person Diane Walshe describes in her letter with the person who stands before me for sentence. Mr. Walsh, you can stand. Mr. Walsh, you will live with the guilt and burden of Ana Walshe's death for the rest of your life. As to count 1, the jury having convicted you of murder in the first degree, I sentence you to life in prison without the possibility of parole. As to indictment 2, lying to the police in connection with the investigation of a life felony, I sentence you to no less than 19 years, no more than 20 years, the statutory maximum, in prison to be served consecutive to the life sentence in 001. The legislature caps the maximum sentence for the improper disposal of a body at 3 years in state prison. As to indictment 003, the improper disposal of the body of your wife, Ana Walshe, I sentence you to no less than 2 years, 364 days, and no more than 3 years in state prison to run consecutive to the sentences in 001 and 002.
Leonard, you've heard about some of my misadventures when moving from Southern California to, well, Massachusetts. And I do not want to be embarrassed again with the wrong footwear for the environment. And that's what I appreciate most about today's sponsor, BRUNT. Because BRUNT removes all of my missteps from the past and just provides a fantastic work boot. Not only are these incredibly comfortable and easy to break in, but BRUNT boots also come with a variety of different heel styles, so you can find the boot that's right for your work environment. And the Marin boot that I am so excited about is a work boot that checks every box. Not only is it lightweight, but it is waterproof, slip and oil resistant, heat resistant, and electrical hazard rated. It's time to check out BRUNT because not only do they have free shipping, but they are dropping limited edition styles all month long. And we know that those are going to sell out because there are more than 500,000 customers that also love their BRUNT boots. So Leonard, with temperatures dropping and the holidays coming up, it's time to treat yourself or a loved one to real comfort. So skip the throwaway gifts and get something that will last. BRUNT workwear. And right now, our listeners get $10 off their entire order with code LAWNERD. So head to bruntworkwear.com and use code LAWNERD. That's bruntworkwear.com, code LAWNERD for $10 off. And remember, they have free shipping. So order today and let them know that the Emily Show Case Briefs sent you. Let's get back to today's episode. We did not see Brian Walshe speak at the sentencing. I imagine that was either already discussed with his attorneys prior to the court, because the court didn't even ask, will Brian Walshe be making a statement? There was no question about it. The prosecution and defense argued for what sentences they wanted to impose, but ultimately the court's strong statements against the defendant's actions, indicating that there was no mitigation in this case, and making it very clear that this is a case where the maximum potential sentence, consecutive after one another, is the only appropriate remedy, even though the defendant will be incarcerated for the rest of his natural life, as the clerk told him when the clerk officially pronounced sentence. So what did the court sentence Brian Walshe to? Well, life without the possibility of parole on count 1. On count 2, the obstruction or lying to law enforcement, no less than 19 years, no more than 20, which clarifies that the maximum on that is 20 years. And then on count 3, the disinterment of Ana Walshe, the court sentenced him to 2 years, 364 days at a minimum, 3 years at a maximum, consecutive. That sentence lets you know exactly how the court feels about this case. And we saw the court comment on the defendant, his actions, and his long history of lying, which seemed to be the only thing that elicited a reaction, even though it was not as large of a reaction as we have seen. We have seen some very small responses from Brian Walshe in court, including the way he reacted to the court commenting on his federal case. What comes next? Well, the defense may make another motion for new trial. They may just go straight to appeal, but there will be an extensive appeal process in this case. We will see if any of Ana Walshe's friends come forward in the days and weeks to come to share their memories of Ana Walshe. And the court talked about how humanizing to Ana Walshe it was when Jem and Alyssa testified in court. And I think the court noted that particularly, not just because it was, but I think it was the court's way of acknowledging the difficulty of coming into court, sitting face to face with the defendant and giving your testimony. I also think early on in the case, we saw glimpses of that with the woman who just had a kind of chance conversation at the nail salon with Ana Walshe, the people who worked out with her. We got to see glimpses of her throughout the case. And though I am and remain deeply frustrated by the fact that some of the victims' photos in court were just in evidence the way they were, some of them were blurred, I also understand the courts going quite a long way to protect the constitutional rights of the defendant, because after all, a criminal trial is about protecting the constitutional rights of the defendant first and primarily. And that can be a frustrating balance when it feels like the victims get lost in that pursuit. And I think the court, though I was personally frustrated at times, I think the court has done everything that they can to protect this from appeal, because at the end of the day, allowing this case to be final and the sentence to stand is the best way they can protect all of those grieving in this case, so they do not have to do it again, even when it's frustrating. Again, I rather them do it right and make sure that they protect it. And this court and these attorneys well know the temperament of the appellate courts and the Supreme Judicial Court in their district more than me. The rulings throughout this trial, because a lot of you are going to ask me what will be the grounds for appeal. The defense will find them. But I think the court's rulings were restrained. I also think that the prosecution, at times to my own frustration, because of course, at times the prosecution, I think, was quite restrained. There was more they could have commented on that they didn't. There was more they could have done that they didn't. I think they protected the record in this case from appeal the best that they could. And I have not seen anything on this record, and we have not looked at all the pretrial. I've not seen anything on this record that is going to cause me grave concerns. So when this goes to appeal, we'll look at it together. That will be the appropriate time for us to look together at some of those pretrial rulings that we have not covered. I'm curious. A lot of you have asked me about the pretrial rulings. We will get to see those rulings when we start looking at the appeal, and I will look at the appeal with you. So at the end of the day, Brian Walshe is sentenced to prison for the rest of his natural life. I think the questions that will come next will be, will there be access to some of the evidence in this case? Some possibly, but not all of it. Will we ever see and the law nerds wouldn't ask this, I think the broader internet might, but will we see the impact letters? Those will be part of the record that people can see, not the children's. So if we see the letter that the defendant's mother wrote to the court, we will absolutely cover that. I am also curious. And I'm not going to stop following the civil case involving Brian Walshe's mother and their landlord. We're going to follow that for sure. The court did make a particular note to say that she could not reconcile the things that the defendant's mother said in her letter and the person standing in front of her. I will try to not judge too harshly out loud, but my feelings on that may change if there is more information we know about the defendant's mother from Alyssa Kirby, for one, because it does not surprise me that the defendant's mother, from everything we have seen, is still maybe in a bit of disbelief. I don't know if that's a protective mechanism. I don't know if that is a fervent desire to not take into account the facts in this case. I don't know, but it is hard for me to wrap my mind around the fact that Brian Walshe's mother was sitting in court through this case and through this evidence and through the prosecution's statements with more information today than we've heard in other court hearings about how Ana Walshe was disposed of. It's hard to reconcile that someone can sit in court and see everything that we've seen and still disagree. Then again, I have existed as a human that has access to the internet. And so I have seen how people can look at one thing and say, No, that thing's something completely different. But it was interesting for me to hear that the court looked at that federal fraud case as the defendant's history of deceit and noted that to the lying to police. If we have the prosecution's motion for sentencing, we'll cover it later, because in that motion, they illuminated how costly this investigation was. But I am still a little bit impacted by the prosecution's statement to the court when the defendant pled guilty on counts 2 and 3, that it was the defendant's lying to police that delayed them from being able to recover various dumpsters, and that those dumpsters had already been incinerated. It is a difficult fact in this case, and I wonder if the defendant hadn't pled to the dissuading police, if that would have come up. And I'm surprised it didn't come up in sentencing. I'm surprised it didn't come up at trial. If that is a fact that is known, it seems that that fact could have been put on the record, that on these dates, we saw which dumpsters the defendant went to. It surprises me that they didn't bring in a witness to say this dumpster was recovered on this day and disposed of and how. There are still lingering questions about why the defendant wasn't made to tell anyone where Ana Walshe was. And I think it's because the prosecution knows there is not much that can be done, unfortunately, after the fact.
What led you to the guilty verdict?
The testimony and evidence.
The group of 12 rendered its verdict Monday after 6 hours of deliberation. Prosecutors presented evidence that Walshe killed his wife Ana 3 years ago in their Cohasset home, then dismembered her body and dumped her remains, which have not been found. Walshe's defense attorneys argued he found Ana dead in bed, suffering a sudden unexplained death, a claim the jury apparently did not believe.
His worry about that she had sudden death in bed and he panicked and got rid of her body. The jury did not believe that. So it wasn't really a question of whether or not we would find him not guilty. It was more a question of murder in the first degree versus murder in the second degree.
This juror tells us while some considered second degree, they reached agreement that there was premeditation.
At any point when this was happening, or even right before, Brian could have made a different choice. He could have stopped.
She is heartbroken for Ana's 3 children and hopes her family and friends will find some peace.
I pray that her...
And that's where the premeditation bit comes in, right? That's exactly where the premeditation comes in. He could have stopped and made a different choice. When we're looking at what the juror had to say over Zoom to WCVB, the juror noted that this was always between first and second degree, that the defense's argument that this was somehow a sudden death and then Brian Walshe found Ana Walshe and freaked out or got scared was not something that they gave any consideration or weight to, that their deliberations focused on which degree of murder, and that their determination was at any time in this, Brian Walshe could have made the choice to stop. And that really is a easy way to describe premeditation. Did you make a choice? Could you have made a different choice? And if the jury believes that that knife in the kitchen was involved, that's not something that is necessarily singularly fatal. So even then, a different choice could be made. And prosecutors have argued premeditation in stabbing cases or cases where knives are used, that a different choice could be made in between different injuries. It's interesting to hear the juror also acknowledge that a different choice could have been made. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerd.app.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.